In the business world today, we operate in a fascinating world of electronic contracting. And when I say it's fascinating, I'm a lawyer who's been practicing law for a long time, and I remember the old days when all contracts for business purposes were almost all written on truly pieces of paper. And today we now live in this world of electronic mail and text messages and Office 365, where our agreements with customers, our agreements with vendors are negotiated and communicated and recorded in many different media. So yes, we still use paper documents for contracts, but a lot of times we may just exchange a Word document through electronic mail. And after we've actually signed an agreement with a vendor or a customer, then time goes by and the relationship evolves. And so commonly today, as the relationship evolves, the two parties to the agreement communicate with each other in a very rich way, in a way that we didn't communicate in the 1980s, for example. Today, we're able and do use text messages, for example, to communicate about performance under the agreement. We might have some kind of an online environment like Office 365, where the vendor and the corporate customer exchange messages, they exchange comments, they may embed comments in a document like a Word document. All of these electronic communications can affect the final agreement. So you may have an original paper contract with your vendor, but then the years go by and a rich collection of electronic records come to modify the agreement. They may amend the agreement in a direct sense, or they may amend the interpretation of the agreement. So it's very important for organizations to fully recognize all the different ways that electronic records can affect the contract that they have with their trading partners. And therefore, organizations are wise, number one, read all of the electronic communications that relate to that contract, because those electronic communications could be more legally binding than you might think. Number two, try to make records of all the relevant electronic communications, including emails and text messages, so that you know what the deal is, so that if you end up in a dispute, you can refer back to that email from a year ago and say, look, it was stated here that the interpretation of the contract is this thing or the other kind of thing. Finally, a wise organization recognizes that the informal types of communications that are available today, like text messages, can be a powerful way to help tilt a contractual relationship a little bit in favor of more of what you want. So as the time goes by in a relationship, you can send text messages, you can send emails that help to document your up-to-date interpretation of what that old paper contract actually means. And that can help ultimately to be persuasive in court or negotiations in the future to make clear that contract was giving me the kinds of support and expectations that I really need. In order to learn more about the course that I teach at the SANS Institute, you can click the link below. Also, another link below provides more information about me and my work in private practice.